Welcome back. Now, a will is an important document that helps to relay the wishes of its writer and owner once he or she passes on. Many South Africans die without saying what they want to happen to their estate. Arabile Gumede spoke to a Johannesburg attorney on the importance of getting a last will and testament.
The death of a loved one is often difficult to deal with, making the division of an estate the least of a family's concerns. But this attorney says that shouldn't be the case.
The general mistake that people make is to live under the belief that it is a person who's amassed certain amounts of money, who's got assets. But as the document is really called, it's a last will and testament. You may not necessarily bequeath anything in your will, but it is to help you express your last wishes.
Writing up the will is just the first step. Keeping it updated and making sure all your assets are included is just as important. Although its contents are usually made public after the funeral, one or more persons need to know that you have a will.
It would be very wise to keep at least one person on the loop, if not two, as to whom your will is with, so that in the event that the person with whom your will is with does not get the information of your passing in time, he or she is able to come up forward and say, here is the last will and testament of this person. This is the nominated executor who's going to take care of the affairs.
But how does one find out about who the executor is? And what if you want to change executors?
The will itself is meant to make provision for an executor. So an executor is nominated in the will. Generally, if, for instance, a person goes to an attorney, it is that law firm, anybody from that law firm or the attorney who helped with the drafting itself, who then becomes the executor who handles the affairs in winding up the estate of the deceased.
If your loved one dies without leaving a will, there are some processes that have to be followed.
A relative of the person who passes on would have to get, depending on the amount of the estates, would have to get a letter of authority or a letter of executorship. So if the estate does not surpass a certain amount, which is 250,000 rand, it will be in the magistrate's court and that person will get a letter of authority. Whereas if it were an estate that is very big in terms of value, that matter would then have to be reported before the master of the High Court.
Writing up a will takes less than 3 hours, and the cost may vary in accordance with the complexity and size of the estate. But not many leave one behind, and attorneys are now calling on all South Africans to change this culture so that their loved ones are not left in the dark.
Well, we know how important it is to know where you want to leave your wealth should you create your wealth. So for more advice on how to protect your wealth and your assets, we join now by Irene Rome of Irene Rome Attorneys. Irene, thanks so much for your time today.
Thank you.
Why is this so important?
It allows you to determine exactly how you want your estate to be divided up. And if you, in the absence of a will, you lose certain protections. A, you don't know where your money is going to. B, you may have to provide security for the executor to wind up the estate. Yeah. And also, if you have minor children, it provides for who will have custody and guardianship over the children, as well as allowing the money to be looked after by a trust or by a person and not go into the guardian's fund.
Oh. So let's talk about the worst case scenario. If you don't have one, what could potentially happen?
Okay. If you don't have a will, you die what they technically call intestate. What you have to do then is that the estate still has to be reported to the master, and depending on the value of the estate, you will have to go through certain processes. If it's a larger estate, then what you'll have to do is you'll have to have an executor appointed with letters of executorship, and you will also have to apply for security for that executor to be appointed. And a security bond is rather expensive. I've had a recent case where in fact, the will had been lost. The master didn't accept a copy of the will, yeah. And we had to apply for security, which is 0.5% of the value of the estate, which is it's not the master has a discretion in that regard, but effectively you're going to be paying quite a lot of money just to get that security bond.
In fact, that brings me to the validity then. How do you know if your will is valid or not? You're saying that in the case of a copy, they're not going to accept it?
Well, my advice to anyone who hasn't got a will is A, to get a will,
Yeah.
and secondly, that make sure that you comply with the formalities in the Wills Act, because if you do, then there shouldn't be a problem of the will being accepted. It's not so difficult, but it is one time where I think that you are better off going and getting advice rather than doing something by yourself.
Okay.
Because when I was at law school, I had a professor, and I remember his words: if you don't do it right, you're going to have a lot of people running after you when you get to the other side. You better have your tappies.
I can imagine. I can imagine.
But essentially, it's not very difficult. I mean, what you have to do is you have to have capacity, which means you have to be of an age to make a will. You have to have it has to be in writing. It doesn't necessarily have to be typed. Each page it has to be witnessed by not only by the testator is the person who's signing the will, by two witnesses, and all those people have to be present in the room at the same time, and they each have to sign each page. The will has to be dated, and it has to be signed at the end, and dated at the end where you signed it. So that, and essentially, then in that will, you would also specify who you want as an executor or executors, who you want to leave your monies to, whether you waive security or not. That's one of the frequent clauses that you can put into a will. And then if you have minor children, who you want to have guardianship and custody of those minor children in the event there isn't a surviving parent.
And as circumstances change, how often should one change it, would you say?
Well, I think a lot of often you can draft a will that is generic, so you don't really have to change it all the time, but there are things that you have to take into consideration. Obviously, children's needs, different family changes, but you can draft it in a way where you say, "All children born to me," so that you don't have, even if another child comes along 3 years later, or another 5 children come along, they would be covered by the will. You also, but you should update it and make sure that you're up to date with it. Also, tax changes; those are quite significant.
So do have a look at it once in a while.
And you know that you do have to have a look at it.
All right, we'll leave it there. Thanks for your time today.
Thank you.
Was Irene Rome of Irene Rome Attorneys. Now, in international news, after buying $1.6 trillion, or 17 times South Africa's yearly budget in securities, the U.S. Federal Reserve has officially ended its quantitative easing program. Our U.S. correspondent, Nick Harper, joins us now from New York for more news. Nick, thank you so much for your time today. So, as expected, the Fed confirming the end of their third round of quantitative easing. How did the markets react to that?
Well, there's been quite a dramatic reaction really during the course of the day. Up until the announcement, which was at 2 p.m. our time here, they were pretty much holding their breath. We saw a bit of a decline from the market. They seemed slightly nervous, awaiting the actual news. And on the news of the end of the stimulus program, they dropped by about 0.25%. There has been a slight recovery since then in the last hour, but they are still very volatile. And just a few moments ago, all three markets were down. The Dow down by 0.4%, the S&P down by 0.5%, and the Nasdaq down by 0.6%.
Of course, all of us want to know when they're going to be hiking rates. Any indication in their statement of what they decided on that?
Well, yes, that's the thing that all investors are wondering, when exactly interest rates will rise. The Federal Reserve said that they will continue to keep them for a considerable time at this near 0% low for some time after the end of this bond buying program. The thinking is that that will probably start in about the middle of next year. However, the Fed have put in this caveat saying that they could raise them earlier if they see improved data especially in terms of employment and inflation.
Well, the Fed seemed to be quite confident that there's been a substantial improvement, particularly in the labor outlook since QE was introduced. Does the data support that, Nick?
Well, absolutely. I mean, in terms of the labour market, we've seen a dramatic drop in the unemployment rate when this third round of quantitative easing started just over 2 years ago. It was at 8.1%, and it's now dropped down to 5.9%, so more than a 2% drop in the unemployment. Overall, the Fed does seem confident the economy is back on track, but they are suggesting that the jobs market does need to improve further. They're simply saying that they need to see better gains, and that seems to be why they still want to keep these interest rates low.
Thanks so much to Nick Harper, who is our US correspondent. Our daily question and answer feature is up next. Stay with us.